Hi, I'm Michael Santos with Prison Professors, and today I'm going to be speaking with you about the administrative remedy process. Now, on our website at prisonprofessors.com, you will see at the top of the list, I'm going to try and show you right here, if you just click on that section that says resources, there is a section that speaks about these different topics that we offer resources on to help. And under the advocacy section, you can click on that link right there, and you'll come to this page where there's a little video that describes what we do. We try to provide content regularly that people can use, all justice impacted people can use, but particularly if you're going into the Bureau of Prisons. So if you click on that particular link, learning about the administrative remedy process, which is really important, you will see this page right here. And that's what I'm going to be doing today, is I'm going to read through this page because you may be listening to this information while you're driving down the road through our podcast on Prison Professors. You could potentially be just looking at the PDF, which you could download. You'll notice at the top of the page, although you can't say this if you're listening on the audio form, you will see that I give an opportunity to download the page. You just click on that link right there, and it will take you to the PDF. And with the PDF, you can print it or mail it or send it to anybody. You will see examples of the actual program statement, which is right here. And this is the program statement that guides administrative remedy within the Bureau of Prisons. So the more a person knows about the product or about the administrative remedy process, the more effectively that person can advocate for himself or for herself if they're in prison. And that's something that people have to be thinking about if they're going into the system. How do I advocate for myself when I won't have an attorney? So this document here, I'm just going to go ahead and read from on the screen with hopes that you find it helpful as you're working through these challenging times. So it says Program Statement 1330.18 governs the administrative remedy process in the Bureau of Prisons. And this page will provide information on the process and also commentary from our team at Prison Professors. That's me. So I am Michael Santos. I was in prison, for those of you who don't know, for 9,500 days as a result of bad decisions I made when I was 20. But I learned a lot through that process, and in order to try and be the change that I want to see in the world, I offer it through our nonprofit here at Prison Professors for anybody that wants to learn. So as you'll see on the left, you'll see that image there. That's what a BP9 form looks like. You could get samples of all the forms by clicking that link there in the middle, where I offer a BP9, a BP10, and a BP11. And again, the other link shows the program statement itself, as well as an opportunity to download the PDF if you want to send this to a loved one in prison. Here's kind of how the course goes. So let me see if I can move this over a little bit on my screen so I could see it a little bit better without anything missing. There we go. And I'm just going to scroll down as I read, again, with hopes of helping people that might not have access to the video portion of this program. So to start the administrative process, the administrative remedy process can be long and cumbersome. While going through 9,500 days of prisons of every security level, I had to use it many times. The more a person understands the process, the more successful a person will be in using the process. Now, in this era of the First Step Act, people should invest time to learn how the process unfolds. Before a person can seek relief from federal court, a judge will most likely require the person to exhaust administrative remedy procedures. Those procedures follows. You have to start by making an informal complaint with the appropriate staff member. You have to take the first step of filing a formal administrative remedy request with the warden, known as a BP9, and you can see the link above for access to the BP9 form. If you don't get the answer you want, you take the next step by filing an appeal to the regional director with a BP10. And if you don't get it from the BP10, then you can file the next appeal, which goes to the general counsel at the BOP's central office in Washington, D.C. through the BP11. Now, it's important to know that administrators may or may not respond to the request for administrative remedy. Despite expecting people to adhere to the policies, a person in prison should expect to face obstacles from staff. And those people in prison should also expect that staff members may not adhere to their own policies. So a person must learn to become an expert at self-advocacy, always understanding the importance of pushing forward, documenting the journey, and working to build a record that will persuade others to grant relief. Such tactics are far more meaningful now during this era of the First Step Act. Now, as an aside, I told you I'd give you some commentary. The reason it's so important in this era of the First Step Act is because the First Step Act provides a mechanism that can result in either an earlier transition to home confinement or potentially compassionate release for qualified people. But all of that has to start with the administrative remedy process. So either you have to find somebody that can help you, and there are many people in prison that may have those skills. My old partner, Sean Hopwood, was in prison, and now he's a lawyer at Georgetown. But he certainly had those skills. Some prisons, you have people that will masquerade as having the skills. The challenge, of course, in prison is that you don't have access to all the resources. But we want to provide as much as we can to help people who need to advocate for themselves. So, to preserve legal rights, a person must become an expert with the administrative remedy process. Again, it's not only for the First Step Act, but for any challenge a person faces in prison. And there are many challenges that come in prison. If a person doesn't complete all the steps of the administrative remedy process, a person could lose opportunities in federal court. Now, a person must develop discipline and the mental strength to navigate a bureaucracy that feels designed to obliterate hope. By being persistent, I found ways to overcome obstacles. Anyone who makes a commitment to success can do the same. Self-advocacy doesn't always mean we get what we want. But if we go through the process successfully, we can restore confidence and populate a record that may advance our advocacy efforts in other ways. So let's get started on the administrative remedy process, and that has to start with this informal complaint, which I describe here as step one. Each local institution has its own rules, and a person must adhere to the rules of the institution. If a person anticipates that administrators will erect obstacles or sow seeds to block an administrative remedy request, well, then the person can take more care to conform so that he will follow all the rules and lessen a staff member's opportunity to block it. So to start the complaint, ask the counselor about the informal complaint process. That way you get to know exactly what's going on in that local institution. And when the counselor responds, make a note of the date and time of the conversation. Once the counselor explains the process, then the individual who wants to launch an administrative remedy should follow that process precisely. Now, when writing the informal complaint, and that's usually on a cop-out form, just write the date and that the incident happened. Not the date that you're making the complaint, unless it's the same day, which is fine to do. Now, to adhere to the process, write the informal complaint within 20 days of the day of the incident. The sooner, the better. Make sure you pay close attention to the deadlines. If you fall outside of the deadlines, the staff may reject the complaint because the time to complain has expired. Now, earlier I showed you Program Statement 1300. I don't know if it shows up here completely on the screen. It doesn't because it's kind of wide. But if you scroll down there, you will get a lot of information on the timelines that I am talking about right here in this video. So make sure that you understand the timelines and that you adhere to them. So where did I go? I think I went to the wrong reading there. So we're going to stick with the informal complaint section. So when writing the informal complaint, where was I here? When writing the informal complaint, where was I? When writing the informal complaint, usually on a cop-out, write the date. I just mentioned all that. So you want to write the date the incident happened. You want to write the date that you made the informal complaint. Now, although a person in prison must adhere to the deadline of 20 days, the staff members do not have a deadline to respond. They may not respond. Nevertheless, you must populate your own record showing that you attempted to resolve the matter with an informal complaint. That's really important because you have to anticipate later down the process, they're going to look for opportunities to squash your administrative remedy by saying you didn't comply with some type of rule or things like that. And so you want to just be aware that this is how the system operates. And if you understand it, you can you can position yourself to succeed anyway. So once you have a record that you've lodged an informal complaint, you can immediately launch the formal complaint because you've got this deadline of 20 days. Based on my experience, I would recommend filing the informal complaint 1 day. You might wait 1 day as a courtesy before you file the administrative remedy. But as soon as you're ready, either it's right away or if you want to be diplomatic and wait an extra day, ask the counselor for the BP9 form so that you can launch the formal complaint, which I explained below how to do. Now remember, the deadline for the formal complaint is the same as the deadline for the informal complaint. So you can't wait around for a response on the informal complaint. That response may never come. So the rules provide 20 days. Get going as soon as possible. So what's step 2? That's filing the BP9 administrative remedy request with the warden. After you have worked through the guidance in step 1 by memorializing your effort to launch an informal complaint, ask the counselor to provide you with a form BP9. It's generally the counselor that provides those forms. The rules require that a person receive this form from the counselor, and the counselor must log your name and the date that you requested the form BP9 in a logbook that the counselor keeps. The counselor's entry into that logbook becomes a part of the record. So for a simple sample BP9, you can look at the link on the top of this page, which I've already showed you, and you can see it's a pretty simple form with a relatively small space to document your complaint. So here are the instructions on BP9, and I put them in a bullet point list. Describe the problem that you want to resolve. Now note on the form above that the BP9 offers, it's really a small space. So if you need additional space, you can write "see attached," and you may attach 1 page to the form. Don't include multiple pages. On the page where you write your description, provide a complete explanation using as many details as possible to strengthen your position. Now only list 1 complaint with each form. If you have different complaints, use different forms. Make sure that you indicate the procedure you followed, beginning with the date and time that you started the informal complaint. If you did not receive a response to your informal complaint, write that the staff member did not respond to your informal complaint. And to comply with deadlines, you filed the formal administrative remedy request. If you received an unfavorable response from the informal complaint, then write that you would disagree with the decision that you received on the informal complaint. For that reason, you're filing a formal administrative remedy request. Bullet point 2. If for any reason you have missed the deadline to file the formal complaint within 20 days, you must explain the reason why. For example, the staff member locked you in the shoe and your counselor did not provide you with the BP9 form. Do your best to comply with the deadlines, anticipating that the BOP will do its best to deny relief. In fact, many people in prison just refer to this process as a kangaroo court. But it's a kangaroo court that you have to go through if you want to advance to the district court level. You always want to memorialize the record. At the end of the form, indicate how you are submitting the form. If you're submitting it to the counselor, write the date and time. If you're putting it into the unit mailbox, write in the date and the time that you're putting it into the mailbox and where the mailbox is. If you're in the hole and you want to submit it to a staff member that works in the hole, write the date and time that you are passing the form to the staff member. And if possible, write the person's name. Make at least 3 copies of the form and the supporting documentation. If you don't have access to a copy machine, then make sure that you handwrite the copies. You will need these copies for the next phase of the process when you appeal to the region, to the central office, and possibly to the district court. Now, your personal record should indicate the date that you filed the BP9, the way that you made copies of the BP9, and the date that you anticipate receiving a response from staff members. To anticipate the approximate date that you expect a response, add 3 weeks, or 21 days to the day that you filed the BP9. Theoretically, the warden is supposed to respond to the BP9 within 20 days after the date that the warden received the form. If staff members notify you that they requested a continuance or an extension of time to respond to your BP9, write the new date that you received from the warden on when they said that they would respond. If you did not receive a response within 21 days or the day of the continuance, then you should advance to the next step in the administrative remedy process, which is an appeal to the region. Now, all of these things you're going to say are very similar. So there's one other thing that you need to know about, and that's the sensitive BP10. In some cases, a person can skip the BP9 process and even the informal complaint and file a sensitive BP10 directly with the regional director. This means you skip the warden and go over the warden's head. But I caution people to use this response sparingly. If the regional director determines that the issue isn't sensitive, well, then the person weakens the entire process because you look like a crybaby. So the BOP is a bureaucracy, and you got to expect that administrators are going to hold people to follow the policy and not to subvert it. That means they want people to file with the warden and give the warden an opportunity to resolve the matter first. And now, an example of a case where a sensitive BP-10 might be appropriate would be if the person is complaining about corruption in the prison or racial disparity or some constitutional violation in the prison where the person's alleging that the warden is involved and perhaps his safety is at risk. So, for example, there have been times when wardens have been accused of being involved in sexually inappropriate behavior with people serving time, and that would be a sensitive issue. You wouldn't want to file that with the warden because the warden has a lot of power and can put you in a situation that is dangerous. So in that situation, it's sensitive. You want to file that directly with the region. And I would recommend you take additional efforts at self-advocacy, but that's getting beyond the scope of this video. So remember, the sensitive 10, only used sparingly. I've never filed one during the 26 years that I served because I could always go through the regular process and pursue the pathway that would lead to success for me. So step 3, and this is after you filed a BP-9, that's when you file a traditional BP-10, and that's an appeal to the regional director. So what are the instructions to complete a BP-10? Well, complete this form if the warden sent a response to your BP-9 that does not resolve the matter in your favor and you believe the warden made an error. Or if you did not receive a response from the warden within the allotted time, well, then you'd also file a BP-10. So you want to file the appeal with the regional director for the region where your prison is located, and I'll put that at the bottom of this page on Prison Professors so that you have all the addresses to all the regional places in the Bureau. If the warden, and of course all those addresses are also available in the law library. If the warden responded to your BP-9 and then begin your response by writing this statement: I disagree with the decision that the warden gave regarding my initial administrative remedy request. I filed that initial administrative remedy request on, and then you're going to insert the date that you filed it, and I'm filing this appeal within the allotted time frame. But if the warden did not respond to your BP-9, begin writing your BP-10 with the following statement: I attach a copy of the administrative remedy request form that I filed on, and then you insert the date. I did not receive a response within 20 days, as the rule for administrative remedies stipulate in Program Statement 1330.18, Section 542.18. I am now exercising my right to appeal in accordance with BOP policy. Okay, so then you're going to use the same description for your problem as you used in the BP-9. You can write out the copy by hand, and you must make at least 2 copies. Make sure that you do not introduce anything new into the BP-10 that you did not introduce in the BP-9. The BOP will only consider what you submitted to the warden. So deadlines. This is really important. As described in the section above on BP-9, make sure that you are conscious of deadlines. The rules require a person to file the BP-10 within 3 weeks of the time the person receives a response to the BP-9 or the time of the extension. Now, be super cautious about maintaining these deadlines or keep an accurate record of why you cannot. Copies. Make sure to attach a copy of the BP-9 that you sent earlier, and also make at least 2 copies of the form BP-10 for the same reasons I wrote about in the previous section. Now, response. The policy provides that the regional director has 30 days to respond to the BP-10. I would recommend that you keep a calendar to memorialize 4 weeks, but expect 5 weeks to allow for mail slowdowns. Now, keep an accurate record in the same way that we describe above. Number 1, what's the date you filed the 9? Number 2, what's the date you received or expected to receive a response to the 9? Number 3, the date you filed the 10. Number 4, the date you received or expected to receive a response to the 10. Now, when the time is right, if you don't get the answers you want, you're going to then proceed to the final stage of the administrative remedy process, which is the appeal to the general counsel in the central office, and that would go on form BP-11. So that's step 4. You want to file a BP-11. It's just an appeal with the BOP general counsel in D.C. If the regional director didn't respond to the BP-10 or responded to the BP-10, but you do not think the regional director made the correct decision, that's when you take the next step of filing the BP-11. So when the staff member provides you with the response to the BP-10, you request from that staff member a BP-11 to appeal. You have to get these forms from the staff members because they've got to log them into a book. All that becomes a part of the record. Don't fall for this that they don't have them. You've got a right to get them, and they've got a duty to provide them to you. If they don't, then you're going to want to write your own BP11, and that's why I put a sample of what they're supposed to look like and explain what happened. But let's go into, I've never heard of them not giving you one. They're going to give you pushback, but as long as you know the rules, you follow the rules. You've got to follow the rules regardless if they do. So you want to file your BP11 at the following address. It goes to the Bureau of Prisons, the National Inmate Appeals Administrator, the Office of General Counsel. That's 321st Street Northwest in Washington, D.C., zip 20534. Now, you're going to use the same instructions that I provided in the previous section, but begin by writing, I disagree with the regional director's decision regarding my administrative remedy appeal, and I request that I filed on the given date, and consistent with the BOP policy, I am filing this appeal. Now, you should write your description again in the same way that you wrote in the BP9 and the BP10. Make sure that you create 3 copies of the page, even if you have to write by hand. Write them. I mean, I had to do that many times. I'm sitting in the shoe and I'm writing many long form descriptions of what happened. But I'm always having to write it like 3 times because you need your copy and you don't have access to a copy machine. So that's why it's a long and cumbersome process. You should deadlines. Write the manner you're using write the manner that you're using to submit the appeal, indicating whether you put it in a mailbox or handed it to a staff member. But make sure you always put the date and time and any details you can. Where was the mailbox, right? Anticipate problems and then figure out how you're going to resolve those problems. That's how I prevailed. So deadline. The rules require people to file the appeal to headquarters within 30 days of the date that the regional director responded. If there is a valid reason for being late, be clear in explaining the reason for missing the deadline. It had better be a good reason beyond the person's ability to control, because you just can't do it say that you were disorganized. You've got to adhere to these timelines or the BOP will say it's untimely and it'll be the end of the story. So attachments. You want to attach a copy of the BP9 and a copy of the BP10. You want to make sure that you have at least 2 copies of the BP11, even if you must write it by hand. So just so to be clear, at the conclusion of the process, you want to have 2 copies of the informal complaint, 2 copies of the BP9, 2 copies of the BP10, 2 copies of the BP11, because you're going to need those copies if you choose to advance this process to the district court. And that's particularly important for people that are pursuing compassionate release. Records. Make sure that you memorialize all dates with accurate records. Keep a record as follows. I am filing my BP11 on, insert the date, which is within 30 days of the time I received the regional director's response. I made 2 copies of my BP11 and have 2 copies of the previous submissions. I expect to get a response to my BP11 within 40 days, but I will wait 45 days, just to account for mail delays. And if the regional director did not respond to the BP10 with the appropriate time, then follow the exact same instructions above, just change the first sentence to read, I have complied with all deadlines in my administrative remedy request, but I did not receive a response from the regional director within 35 days, and for that reason, I am filing this appeal. Okay, that would exhaust the procedure. So the next steps is, by adhering to the steps above, you have appropriately gone through administrative remedy process, but if you did not receive the response you wanted at the conclusion, you can accurately state on a motion that you've exhausted the pursuit of relief through administrative remedy. And you can now bring your case to the U.S. District Court through the appropriate filing. And depending on the matter, that filing may be a Section 2255, it may be a Section 2241, or some other type of motion. If you file pro se or without an attorney, you can ask the court to construe your motion liberally. That's in accordance with some Supreme Court rulings, which I describe in other areas on prison professors. So this is really the pathway to be thinking about administrative remedy. I know it's complicated. I know it's long and cumbersome. I had to go through it many times, but that's why I want to provide as much information as possible for people who want to help themselves. Now, as you can see let me see if I can go back to the actual policy. Let me see if I can move this screen so that you could see the whole policy. That's going to take some little maneuvering here on my computer. There we go. Now you can see the policy. So I can scroll down. That's the policy itself, the administrative remedy policy. And you can see some areas that are of particular interest, that should be of particular interest to people that are studying administrative remedies. This applies not only to people in prison, but also community corrections managers, wardens, directors, everybody in the BOP. So it really makes a lot of sense to learn this process, to learn about the deadlines. You can download this policy itself right from Prison Professors. I'm looking for an area here that tells you that you can get help from others, because sometimes staff members want to insinuate that you can't get help. But let me just show you the section that shows you that you can get help. Assistance, that's 542.16, section 10. And that 542.16 refers to the CFR, the Code of Federal Regulations. But it says here, an inmate may obtain assistance from another inmate or from an institutional staff member preparing a request for an appeal. And an inmate may also obtain assistance from outside sources, such as family members or attorneys. But nobody can use this as an excuse for asking for extra time. The system, the people in prison, the staff members that work for the prison system can ask for extra time. They don't really allow people in serving time to serve time. And you see, I always try to remove that vernacular of inmate or convict or whatever. You're a human being, and I believe in you, and I believe that you should learn how to advocate for yourself. Those are the strategies that worked for me. I am Michael Santos with Prison Professors, and happy that you can access this content, whether you're looking at our channel on YouTube, our website at prisonprofessors.com, or on iTunes or anywhere else. We do ask that you subscribe to support the program. This is the way that we strive to be the change that we want to see in the world. We believe in you, and we hope that you find this information helpful. If you do, share it with your attorney and use it, and subscribe to us. Thanks so much.